Hi everyone, it's Grant Abbott speaking from LightYear Docs and also Abbott and Mourly Lawyers. You may have recognised probably over the last year or two that we've taken a completely different style. We're not just an online document provider, we're more importantly a strategy provider, being able to build document automation. And I think that enables us to provide a lot more value to all of our users, particularly our strategist users, when they come around to do like advanced strategies such as the protector, the enforcer, or even our loan agreements, which now have loan agreements with personal guarantees and mortgage deeds built within them. And this is really important because when you're building something for a client or a strategy for a client, you want to make sure that you get all the documentation in line. One missed document can make the whole thing fall down. You can have a look at Mercanti and Mercanti. You can have a look at Repermuan, where lawyers are basically stuffed up in terms of their documentation. So for us, it's really important to build that documentation. Now, on a scale of 1 to 10, when it comes to exactly the right documentation to build a strategy, you guys are probably down around about a 2. And there's nothing wrong with that. I mean, with Abbott and Mourly, I mean, that's our job. We not only know the breadth of documentation, but more importantly, what is really needed to make it sing and take it to the next level, which is why we sign off on all the documents. We build those chain of documents in LightYear Docs. So we're not a document, we're more of a strategy builder for your clients, and that's pretty important, which is going to take a couple of new turns. And I just wanted to give you a bit of a preemption on this one, just to get your mind thinking, because be careful and have a look at, if you go to LightYear Docs and have a look at the events, which is either on the Surge or the main page, we've got a whole range of launches coming up, a whole range of webinars. So make sure you're on our webinars. They're completely free, and we put out at least 24 hours a year for all of our members. You got 6 just a little while ago when we did my 30 years of strategies. And I've got, hopefully another 30 years in me. We'll wait and see. Importantly, though, I just want to cover 2 areas that you won't see anywhere else. First, and probably the most important, is coming up to, obviously, trust resolutions. Now, with Owi's case, and many of you probably well aware of it, it was a Victorian case. Is it localised to Victoria? They removed the trustee because the mother, or the matriarch of the family, who was also one of the trustees, distributed directly down to one of her children in concert with herself and also her husband, but failed to take into account the financial needs of other named beneficiaries. They removed her as a trustee, and anyway, that the court appointed a lawyer as a trustee, and then obviously changes were made to that trust. So it's obviously have great concern. The other side is also Section 100A, where there needs to be a reimbursement agreement. We've had a look at Guardian case and all of these sort of issues. Now, I'm not going to drone on about that because you've probably heard me speak about it, or certainly Tim Munro has spoken about it a long time. But what we're going to do is, it's really important, is trust resolutions are coming up. Now, up in the next week or so, what will happen is you'll actually have the ability to add a letter of advice to your clients, detailing their requirements from a trust perspective, detailing the impact of OE, the 5 key points that are coming out of OE's case, and looking at also at Section 100A and a couple of no-nos. Now, that bears 2 things for your clients. One is that by doing a letter of advice, which will come out on your logo and also with your signature, it enables you to either, well, first off, you can charge more because you're giving a letter of advice around some very important issues, and the advice has been drafted by Abbott and Mourly, but we've put your logo, or you can put your logo and your signature on there. Secondly, is that if you have that letter of advice, at least with your clients, they're aware of what's going on. So if suddenly there's blowback later on, then effectively at least you're going to be covered there. The second one, so that's coming up, and that'll be ready very shortly. Just watch out, there'll be a pop-up webinar where I'll go through the whole package for you, and that'll probably come out in about 10 days. The letter of advice is done. I just need to tweak it a little bit further, test it out, and get it on the system. The second one, which is also going to be launched in a couple of months, which I find is extremely exciting, Many of you probably do BDBNs, which essentially just simply put a certain percentage to the spouse. And, if you've got a good BDBN, then they might actually drop it down to the next level if that person's not alive. If your BDBN goes over to the estate, then it's a complete waste of time, because you're actually pushing it over into a system whereby it may be subject to family provisions claims. So that's the last thing that you want. So one of the key areas for us, and many people aren't aware of, I can tell you estate planning lawyers aren't aware of it, that there's 3 areas where you can actually build a testamentary trust. One's directly from the will, one's from insurance proceeds. So again, if it goes down to a beneficiary, they can create a testamentary trust when they receive those insurance proceeds, which then means minors coming through there effectively taxed as if they are adults. The other one, which is really important for us, is, again, if someone's a dependent, which includes obviously children, adult children of the deceased, the spouse, anyone who's a de facto relationship with the spouse, and also includes anyone who's a financial dependent on that spouse. And there's a whole breadth of law around that one. Sorry, not a financial dependent of the deceased, sorry, not the spouse. So just jumping along there. Now, when it comes out, again, you can actually, if it goes out to a dependent, the trustee, depending on what a BDBN just doesn't deal with something like this. So you need to go into an SMSF will, which is a BDBN on steroids, because it has a whole set of directions in it. Much the same, look, honestly, it's not much different from a will. And if you think about it, a will creates a testamentary trust, and SMSF will creates a testamentary trust for your super. So it can be directed directly into a testamentary trust for one of your dependents, one of your adult children who might have drug issues or other issues, or even if it goes to the spouse. We've got to be very careful, and I'm not a big fan of giving anyone money directly. And the reason I say that is, if your spouse gets remarried, then that money that's sitting in the pocket, whether it's used to pay off the mortgage or whatever, is effectively going to be in a position that it is going to be laid waste from a family law claim or potential future family provisional litigation. Whereas it's a lot easier just to put the money all into a testamentary trust. If you want to pay off the house debt, then simply lend the money from the testamentary trust to pay off the house debt, and that's fine. But now we've got all the lender being that testamentary trust. And so that testamentary trust option is just, that to me is your go-to SMSF will. Now, when you're building that, what we'll be doing in the LightYear Docs system, much the same way as we'd be able to put a letter of advice at the front end of the trust distribution resolutions, you'll also get a letter of advice around this SMSF will with a testamentary trust. Plus, on top of that, you'll get a full-blown testamentary trust. It'll be based on our leading member discretionary trust, which has no named beneficiaries, absolutely crucial for OEs. But more importantly, from that one is it's also bloodline. So the only beneficiaries can be bloodline, and it vests when the primary beneficiary, who we're going to actually be the leading member appointor, passes away. So that's just the way it works under Section 102 AG of the Income Tax Assessment Act. So you're going to have a really good package: letter of advice, SMSF will, and a testamentary trust for the client. So that's something going to take you from a dodgy old BDBN, which don't work, most of them don't work anyway, of $300 to $400, up to a really sizable package for your clients that's going to protect their bloodline, protect their spouse and any children from family law claims. Plus, you've got a letter of advice, which should be coming in around about $2,800. So that's a recommended retail price that you should be charging for that. Likewise, with the trust distribution resolutions, I'm not sure what you're charging for that, but I'd be charging at least $500 for that letter of advice. So the benefit of LightYear Docs is that essentially we're an automation solution. And I think that that's absolutely crucial. We look at strategies and we continue to add more value. Now, of course, these are generally only going to be able to be utilised by strategist members. We've got some excellent packages from strategist members for one-man bands up to really, firms that are almost multinational. So have a chat with Ben Gill, Ben at lightyeardocs.com.au. No doubt many of you have. And really just get away from thinking a document is a document. You don't want to do that. You have to think a document has to be used in a strategy. I even see people set up discretionary trusts. They get their admin staff to set up a discretionary trust. That's a nightmare because one is admin staff doesn't know the complexities of a discretionary trust. And why would any of you be using a discretionary trust naming primary beneficiaries and other beneficiaries in this day of OEs and Section 100A? It just doesn't make sense. Anyway, it's probably gone on a bit longer than I expected, but I wanted to give you a real lowdown to show you that we're continually thinking, we're continually building, and at one stage we're going to be putting letters of advice across all of our documentation. It's going to take a little while to build that, but that then adds extra value for you. And that's really what we are doing at LightYear Docs and Abbott and Mourly. So please feel free to give us any feedback on Surge. Just remember, if you're a strategist member, again, you've got access to the team at Abbott and Mourly. We've got 10 lawyers now who jump online and will answer your questions in real time. These guys are crack, and they're absolutely amazing. If you saw some of the wills our team are building, it's fantastic. And a final one, if you do have an opportunity, for those of you who are SMSF members or board certified who want to go down the track, make sure you come over between the 7th and 9th of October to Phuket. It's going to be a cracker. It's not a big event. You haven't got hundreds there. It's going to be very focused, two or 3 days of really intense discussion, but more importantly, going to be networking with other people of your like mind. Family wealth protection is definitely the way to go. That's why we need those letters of advice to not only protect your clients, but more importantly, to protect you, because you're really the most important person to us. Anyway, it's Grant Abbott from LightYear Docs and Abbott and Mourly signing off.